We'll kickstart this edition with some news just coming in from the High Court in Karnataka on the hijab showdown. The hearing is underway right now. The High Court is asked if essential religious practices are absolute and if it can't be subjected to regulations. The petitioner referring to the Triple Talaq Judgment. Nolan Pinto getting us the very latest as far as the court's developments. The developments within the court is concerned. Take us to the reference herein to the Triple Talaq Judgment, Nolan, that the petitioner has made. Break this down for us.
Well, Sneha, Advocate Karnataka says if Islamic scriptures of the Holy Quran says this practice is obligatory, then courts have to permit it. In the S. Bano case, the Supreme Court held the Triple Talaq practice was not sanctioned by the Quran. This is what he says. Now, that is when Justice Dixit then questions, says, Mr. Kamath, whether what all stated in the Quran is essential religious practice. This is what he questioned him. Is what all stated in the Quran an essential religious practice, ERP? That is when Advocate Kamath says, I am not saying that. So we're just waiting for more updates to see what really happens over here. But Sneha, very interesting points that they have come out with. I just want our viewers to know that, because in the past 5 odd minutes, Advocate Kamath has actually brought in a lot of important issues. In fact, he refers to one particular case. This is at the Shirur Mutt. This is right there in Udupi itself. He says, and I want to quote him, a religion may not only lay down a code of ethical rules, it might prescribe rituals and observances which are regarded as integral parts of religion, since we were talking about integral part of religion or essential part of religion. And these observances might extend even to matters of food and dress. Then he also refers to, he quotes from the Ratilal Gandhi case saying, no outside authority has any right to say that these are not essential parts of religion, and it is not open to the secular authority of the state to restrict or prohibit them under guise of administering the trust estate. So these are very strong arguments that he's putting forth. However, the Karnataka High Court has actually questioned him, asking, what about Article 25, subsection 2? Kamath says that Article 25.2 has, for the state has been given the power to restrict any economic, financial, political or secular activity associated with religion. This very concept means that other core religious activities of religion can be restricted. The High Court now, this is important, questions him, says, can Article 25.1 and 25.2 be read separately? He says yes. But the Karnataka High Court says if one reads the Bijoy Emmanuel case, it does not distinguish between Articles 25.1 and 25.2. And this is what the High Court says, that Articles 25.1 and 25.2 have to be read together. So these are the arguments which are actually going on as of now. Sneha.
I'm going to go to my colleague Nabila for more on what is being asked about the Holy Quran. The High Court, Nabila, essentially asking whether this really is the first source of Islamic law and whether that everything stated really in the Holy Quran should be treated as inviolable.
Right, here, Sneha, when we speak of the Holy Quran, it is almost like the word of God. There is no debate on what the Holy Quran says for a practicing Muslim. They would go by the word of the Quran, but there's a lot of talk about, apart from what the court is hearing currently, we're also looking at several scholars who've been insisting that there is no specific mention of wearing the hijab in the Quran. It speaks of dressing modestly, but nothing specifically mentioned about wearing the hijab, about wearing a burqa or a veil, etc., which is why it's going to make it slightly tough for the court now to try and break it down to see how is it so essential and whether the Quran itself mandates it. Now, there are several interpretations of the Quran too, Sneha. I must tell you, there are Sharia interpretations to the Quran, and there are several Sharia interpretations to the Quran. In fact, Darul Uloom, which is one of the Islamic centers in India, the most popular, the largest one, which is in Uttar Pradesh, they have a certain rigid way of interpreting the Quran, while there are several other institutions that interpret the Quran individually. But what we see in common of all these interpretations is the hijab. That women across the globe, in fact, Muslim organizations have, or the Sharia interpretations across the globe have insisted on parda, basically the hijab, covering the hair most particularly, but no mention or nothing specific about covering the entire body or wearing the black burqa that we usually see women wearing, or the whole black veil. That's not mandated, but certainly what's common across all of the Sharia interpretations is that wearing the hijab, which means covering the hair and wearing your arm full sleeves, like full sleeves, not showing your hand, is what should be, is how women must be dressed according to Islam. This is what, according to them, is their interpretation of being modestly dressed. But then again, it comes down to a lot of debate whether how women would look at it as whether this is their choice or whether this is imposed on them. That's also a huge discussion there. Many countries actually impose hijab despite women not wanting to wear it. And on the contrary, we're seeing a different debate here altogether. Women wanting to wear it, but here the state government has certain discipline that needs to be that they want to ensure inside classrooms. It is a fine line which the court will be discussing and deliberating on, which is why a verdict today itself seems unlikely here, Sneha.